Get started. Welcome, everybody. Thank you so much for joining today. My name is Kara DeVeris. I'm the Projects and Administration Manager and the Elevate IP Manager for North Forge here in Winnipeg. North Forge is located on Treaty 1 territory in the national homeland of the Red River Métis. We honor the Anishinaabe, Anishinaabe, Innuwak, Dakota, Oyote, and Métis people as the original caretakers of this land. As a not-for-profit innovation hub, North Forge recognizes its responsibility to listen, learn, and act. We are committed to respectfully supporting Indigenous cultural identities and integrity by incorporating Indigenous knowledges and leadership into our programming, governance, and community relationships. North Forge is a not-for-profit tech incubator, accelerator, and state-of-the-art fabrication lab. We fuel Manitoba's innovative, science-based, technology-enabled, and advanced manufacturing startups from ideation to funding by offering unparalleled programming and resources to help startups grow. Our facilities boast one of North America's largest publicly accessible fabrication labs, our Fab Lab, where startups can access cutting-edge tools and technologies. Thank you all for joining today for our Elevate IP monthly webinar series, where we host reputable experts in the intellectual property field to share their valuable insights on various aspects and topics. Over the past 3 years, we've provided expert guidance to startups in Manitoba and Saskatchewan, empowering them to leverage IP as a valuable asset in their growth strategy. From funding patents to tailored IP strategies, we've seen firsthand how critical IP management is to the success of an emerging business. It is now my absolute pleasure to introduce today's keynote speaker, Gill, partner at McKercher, who has just been named 2025 Lexpert Rising Star, a leading lawyer under 40, one of Canada's most prestigious legal honors. Congratulations, Joe. Joe is a technology, capital raising, and tax partner with a particular focus on high growth technology startups, IT contracting for managing digital transformation, and tax structuring for private enterprises and professionals. He has assisted hundreds of prairie technology, innovation, and scientific startups. He works with founders through the startup lifecycle, from the very early ideation stage through formation to growth, scale, and exit as well. Joe brings a unique approach to his advice, having co-founded a legal tech startup that participated in Saskatchewan's first business accelerator program. Joe also serves as the lawyer in residence for Collabs, which is a technology incubator in Saskatoon, the lawyer in residence for Cultivator, a technology incubator in Regina, and a legal coach for Opus, which is a technology incubator operated by the University of Saskatchewan. He is the founder and chair of the firm's technology and high growth startups practice group. And he presents to groups in the startup ecosystem on legal issues such as formation, tax matters, employee incentive planning, privacy, and cybersecurity, as well as securing government funding and raising capital. Also, McKercher is a contributing sponsor of North Forge. So thank you very much. That's just another way that we're connected, and we are so appreciative of you being here today. So Joe, I am going to pass the mic on to you, and we'll start your keynote. Just so everybody knows, we will have a Q&A period after Joe's keynote. So if you have any questions, feel free to put them in the Q&A section of the chat or in the chat, and then we'll read them after. So thank you. Thanks, Joe.
Awesome. Thanks, Kara, for that great intro, and good afternoon to everybody. Thanks for tuning in. I think I need to shorten up that bio. It's getting a little long. It's going to put people to sleep. I should just say I wear fancy blazers and I can put away about 80 to 100 oysters if you take me out to an oyster and cocktail happy hour. I think that's what everybody came here for, right? Really excited to be presenting today on tactical intellectual property issues, and I'll pull up my presentation here in a second, but just a little bit of table setting on this. I think this can be a really wide subject for a lot of people to wrap their heads around. There's a lot of facets and nuance and complexity associated with an intellectual property strategy, intellectual property registrations, filings, everything in between. So we're really just trying to focus in on here are just some hopefully straightforward things that you can do as founders today or in the next couple of weeks to kind of augment how you're thinking about intellectual property, how you're protecting your intellectual property, what is intellectual property, and a few other things along the way. So we're going to have all that. I will say too to everybody, There is a presentation, happy to share that. Just because I assume everybody is now dependent on AI note takers, and you weren't allowed those in this case, I will be preparing a 2-page checklist and cheat sheet of all the major points I'm going to talk through today, and we will be sending that out in the next couple of days after the presentation with a feedback thing. Hopefully you found this useful and you don't use it to slag me, although you can do that too if you really want. With that said, let me pull up the slides here, and I will just share this. Give me 1 second here. Okay, boom, there we go. First success, we got it up here. Okay, so you saw the name, Own It or Lose It, tactical walkthrough of IP issues for founders. Okay, legal presentations are not complete without disclaimers, which is, I do know something, I don't know nothing, but I just say this on the front end that I don't know your circumstances. I know some of your circumstances, actually, to be honest with that, in terms of a few people I've had the pleasure of knowing, but I don't know the deep details of each of your businesses, the IP you're building, all of that other stuff. And I say that because a lot of these journeys are really context driven, and we're going to talk about that today. It's important to understand what works for you. So a lot of the things that are going to be in here, these are best practices that I've gathered advising hundreds of startups over the last couple of years, but they may not be a perfect fit for you. So don't take it as gospel any more than you meeting with an expertise mentor or advisor or anything like that. Again, incorporate what you think is useful. I'm always happy to have individual conversations with people, but for these purposes, again, just take it for what it's worth. These are best practices gathered from a bunch of different circumstances. Okay, few things on the front end as far as what I think are kind of strategy keys when you think about IP. So we talk a lot about IP strategy. The cornerstone in many ways of the ElevateIP program is building an IP strategy if you haven't built one already. But keep in mind, it doesn't exist on an island out at sea. IP strategy is a subset of your business strategy. You're going to have a larger strategy that brings in marketing, research and development, finance, ops, all of sales. All of these other things are going to also drive the business. You can't succeed by ignoring different pieces of that whole in favor of one piece. And the same thing is this. These are important issues, but appreciate how they're situated within a larger strategy. At the end of the day, someone's got to be responsible for this stuff. I'm going to talk about a lot of tactical things. Some of you have probably have gone through the ElevateIP program and have maybe been given strategies. One thing that, whether it was me advising you or somebody else has probably said is, look, somebody's got to do this at the end of the day. So much like you really couldn't run a business without a head of sales or a chief technology officer or a finance or a chief financial officer, somebody's got to be responsible for this stuff. So keep in mind, you're going to have to pick that. If you're a smaller team and you're just the sole founder, it's falling to you, like everything else in the organization. Staged approach. There's this, what's the saying go? There's a season for all things. Just because you hear some interesting stuff in a presentation, like for example, later on, we're going to talk about some stuff that might be important within a company that's thinking about being bought, like mergers and acquisition readiness. But if you're just starting the journey, that doesn't have as much relevance to you. So it's okay to think about that and to have that in the back of your mind, but it's not today's issue. So a lot of things should be taken in kind of a staged approach. I mean, I put in the brackets there, one example is, understand the state of play. We conduct a lot of, through ElevateIP and other places, searches, patent landscapes, trademark searches, industrial design searches. Those are really helpful. If you don't know the lay of the land, if you don't know who else is out there building that same gadget or prototype or whatever, it's very difficult for you to plot a strategy not knowing what's out there. You don't necessarily need to jump right into a full registration strategy if you don't know what's out there. IP is not a silver bullet. This is important stuff. Wouldn't be having a webinar if it wasn't. But despite a robust IP portfolio, you can still lose the game of startup. Like, don't expect that singular focus on IP matters is going to be your ticket to great wealth. It's an important part of it. It goes back to the first point. Treat it as a subset of your business strategy. It's an important part. You should be thinking about it. And I think in many ways, the reason why ElevateIP came into this world is because we weren't having a lot of conversations around IP as a part of business strategy. But don't assume it's the only part of what's going to make you successful as you scale a business. And then talk to other founders, not just experts. Like, I really hope people stick around and network for a little while. I know a number of people, I'm seeing it on the participant list, are founders of companies or have been around a lot of startups and have some interesting advice to give. They might not be IP experts, IP lawyers, agents, etc., but they're proximate enough to these issues that they're going to give you some good advice. And I think for a lot of people who are founders, I've heard this over the years, hearing things from other people on the journey is really important. You know, as advisors, we know our stuff, but sometimes we fall victim to the old saying, to the man with a hammer, every problem is a nail. If you're only singularly focused on one thing, every issue becomes a, you know, finance issue or an HR issue or something like that. Issues are more nuanced than that. Life's multifaceted. So just have a conversation with somebody, even if that's going to be your main takeaway from this presentation. Okay, those are some just big points on the front end of it. Okay, what's the real problem we've got that I'm driving at? Real problem is, and I love this quote from Gandalf, all we have to decide is what to do with the time that is given us. The key point is this: your time allocation determines your success or failure. And also, as we talk through these IP issues, an issue isn't just relevant because of what the issue is, like whether it's a patent issue or a trademark issue or a copyright issue, but it's also relevant based on the urgency of that issue and the proximity of that issue to the core of your business. And that second part really requires you to know what stage of company you're at and what's appropriate for that stage. But where you spend your time is going to deal with exponential outcomes. It's one of the reasons I wanted to build this presentation about, like, what are some quick hitter tactical things you can do? We have limited time in this world. It's about 1,000 things any given founder could be doing at any given moment. And so think critically about what is driving the most value for you. Back again to my comment about context matters. You, as the CEO, founder, co-founder of a business, are in the best position to assess priority, whether that's on IP issues or anybody else. Talk to people, learn from people, but you have to make that assessment. Okay, let's jump in. So the first point up here is we can't begin a journey if we have no idea what we have. So let's start with IP triage. Again, people, I like metaphors. So again, imagine it's a busy emergency room. There are people flying around all over the place. Somebody's losing some fingers. Somebody can't barely breathe. Some other person who just seems relatively fine. We don't know what we have. You're the emergency room doctor or nurse or whatever it is right now. Your job is to figure out, what do we actually have here and where am I going to assess priorities? So one of the first things here is, you know, what are we going to inventory on that? And I've suggested, again, this isn't written in stone somewhere, but I've suggested some buckets you might want to think about as you go through that inventory exercise. You know, if you're a software heavy company, codes and algorithms, the data you're collecting, especially important. Almost every company is leveraging or building some type of AI product. They're collecting reams of data, which they're either using to train their particular AI, or they're ingesting kind of aggregated data to make their product better. What data do you actually consume and how do you use it? Your brand. Like, presumably you have a brand, you have a name, you might have a cool logo, you might have like an ethos, a tagline, some other things around that. You know, document all of that stuff, even innocuous stuff. I've had clients over the years, you know, we go on their website and they have some tagline in there, and I say, well, isn't that kind of what you market yourself and you're having, you know, elevator pitch conversations? And they're like, yeah, we talk about that all the time. Okay, like, you're going to protect it? Like, it's actually a pretty good slogan. Didn't really think about it that way. So all the things around your brand. Designs, user experience. What does your app look like? What's the design of your product? Maybe the particular form factor that you have for you know, a sensor technology, or, you know, a phone. Like, you know, one of the most easy example, like industrial designs we talk about at times, just the form factor that smartphones come in. I mean, I use it also to prove how much, like, it's a game of millimeters in terms of differences, because, you know, I'm sure some people will bite my head off for saying this, but I don't think there's a Marianas Trench of difference between what an iPhone and what an Android or something else looks like. But the design, the way people interact on your website, what are those processes? A lot of founders are quite proud about and spend a lot of time thinking about the user experience. And then know-how, like, it's all the things that are trapped in your gray matter. Like, if you were pulling out a journal and having to write down all the really important key, you know, crown jewel ways of thinking and building things within your company. Processes, might have those documented. If you're an early stage company, you probably don't have a whack load of this stuff. That's fine. Like I said, there's a season for all things. You don't want to get ahead of your skis and turn it into a government bureaucracy for a company that started 2 days ago. But how do you determine things? Like standard operating procedures. Processes can help people. Contracts. Big part of my world is working with companies to streamline contracts, one, for ensuring protection of intellectual property, but also just to streamline, like, sales process, procurement, conversations with people we might collaborate with. So you can go and document all of that, all of those things in terms of like, what do I have today as part of it? And then once you've got that list, then it's, okay, well, maybe we should map these. Like, again, this isn't a presentation on all the heads of different intellectual property. I'm sure there's at least been one other one, and there's a lot of good resources out there. I'll provide some after. But, you know, there's copyright, patent, trademark, trade secret, trademark, industrial designs. And, you know, there is a natural mapping that occurs to a lot of these things. Brand protection, in most cases, maps to trademarks. Your elegant design, maybe you're building some cool add-on for wings on a helicopter or something like that. It's not really about the function of the wings. It's more about the look, the kind of cool, sleek look to them. That's an industrial design. Maybe you're building maybe you have some proprietary code base or whatnot. That might be the subject of a copyright registration. And then a lot of those things I talked about on the other slide, know-how, processes, gray matter, thinking, that could go into the trade secret category. It's part of it. Like there's, you know, the other thing I'll say too is the path may not be intuitive. I mean, this is why I plug for why you participate in these programs and you work with experts. Like one example, consider where customers could cause you harm. So I use an example of, I had a client who thought his designs for like small, like crop dusting airplanes were special because of their aerodynamic qualities. But it actually turns out his competitors were largely ripping them off because of the aesthetic. It's the way they looked, funny enough, and the design more than like the functionality. So in that case, that was more of an industrial design issue than a patent issue. So sometimes you don't know what you have until somebody tries to steal it from you. Maybe it's the lesson there. But appreciate that you should try to engage in some mapping exercise, and that also might be a good exercise for working with advisors. Again, I put some just quick hitter points there. Like when you're going through this, you've identified something, like who worked on the logo, who was the owner of it, where was it done, is there any risk associated with that person leaving? Like, were they a temp person, for instance, an unpaid volunteer, or are they like one of the co-founders and they're like ride or die on this? And then what do we want to do next with it? Maybe it's nothing. Maybe the next action is just we put it in a nice Excel spreadsheet or something like that. We don't need to do anything more. Maybe the other part is like, we think our logo and our brand is super cool and everybody loves it. Trademark. We absolutely need to protect this based upon, you know, public reaction, etc. I will jump to the next point. So some quick triage points just for thought consideration. Like if you're going to launch soon, you can do this thing called it's basically a trademark search. The funny name is knockout search. By the way, if people haven't noticed in life, professionals just give cool names to mundane things to make them sound more important than they actually are. So it's like, as a tax lawyer, they do this all the time because tax is boring. Like there's a fun transaction called a butterfly transaction, because when you draw it, it looks like a butterfly, but it's basically selling assets between two companies in a weird shell game. If you launch soon, you can do this thing called a knockout search, which is basically like, it's a quick search for identifying identical or highly similar marks before filing for protection. So a conventional search would only take the wording into account and not necessarily its graphic or design. It could also cover existing trademarks, expired marks, common law, and abandoned ones as well. So it just gives you kind of like a quick, okay, is somebody out there with this? Even before that, frankly, just Google stuff, frankly. It surprises me how many meetings I have with clients on a even weekly basis where like, go to page 5 of Google. Go that far. I know there's nothing exists to most people past page 1, and people barely use Google now in favor of AI search engines, but like do a little bit of work associated with that. If something's hard to detect, certain data sets, just hard to figure out like why what you're building is really important. We're going to talk about trade secret in more detail, but maybe treat it as a trade secret for now. And we're going to talk about some protections you can do without having to go down, like say a formal patent process or something, but then revisit that later. Again, this theme's going to come up. It's why I mentioned it at the front end. Like today's strategy for something might be one type of protection. Tomorrow's strategy might be different. A lot of it depends on the maturity of the company, the funding of the company, the industry you operate in. the expectations of your investors. For a lot of you who are venture-backed, angel-backed, looking for funding, you'll have a lot of investors who invest in deep tech who very much will want to see certain things versus other things. But keep in mind, you can always come back to this stuff. So maybe it's best just to adopt trade secret controls and revisit stuff later. And then, of course, I got to do plugs for ElevateIP. You can turn your triage and all of this stuff into an ElevateIP-funded work plan. You know, whether that's a tier 2 strategy or it's a tier 3, you know, patent registration, document creation, etc. on that. All of these things are important. Okay. Next thing we're going to talk about. Nice segue. I talked about trade secrets. Why did I focus specifically on trade secrets? Well, the reason for that is I find from experience working with a lot of startups that this tends to be kind of the default ground where people start. And part of the reason for that is there's no registration. Like you don't create a patent application, trademark application, copyright, industrial design application, have to work through that. I think one of the historical reasons too associated with that was, again, most people are bootstrapping. It's their own funds for these startups. And in a world that an ElevateIP doesn't exist, like this stuff isn't cheap in a lot of cases going through, say, building out a full patent portfolio. So that's a lot of the default towards this. As it says here in the slide, trade secret value is derived from secrecy, but you have to protect things. Like protection requires this idea that around, you know, reasonable measures. So let me back up for a second. So what could be a trade secret? Frankly, it's anything, any information with commercial value kept secret through reasonable measures. There isn't any registration in Canada. Examples could be everything from data labeling, recipes, ranking heuristics, scoring, non-obvious operational playbooks, and then my favorite one from a client example, the particular configuration and placement of robotic arms that golf. Trade secrets says the word reasonable measures. People scratch their head and go, what does that mean? Thankfully, we have some court decisions. Some judges have figured this out, so I didn't have to. There's some measures you took to maintain secrecy. Maybe you like told everybody they got to sign NDAs. The information has value out there. Like if competitors got their hands in it, they could cause you some damage. There's some, you know, non-trivial cost of money or time in creating or developing it. Like it didn't take you 5 seconds to build it. You had to do some work for it. The ease with which somebody could just independently develop it. Like if it's obvious to the person walking down the street what you did, it's not so much. But if it would take some brain power to do it, that's a different story. The degree to which you treat it as confidential. I mean, if you're going around to cocktail receptions and telling everybody about how your robotic golf arms work, you know, it's not really that secret. But if you're just, you know, it's like what's the saying, loose lips sink ships. The degree to which if you were to share it with somebody, like if you were going to collaborate with another startup, for instance, would they think it was confidential and important? They go, ooh, this is pretty like top secret stuff here. Or they might go, this is the most obvious thing I've ever heard in my life. And then, you know, the second last point is whether the person receiving it ought to have known it was confidential. Again, they kind of look at it. Is this something that seems like a state secret or is this pretty obvious? And then finally, whether if they had it, it would cause you some harm. It's kind of tied back to the earlier point about the value. Like there is stuff that would leak out into the world as far as like competitive information that probably isn't going to harm your business. There's other stuff though that absolutely will cause issues. I talk about this in the other slides. You don't have to register it to enforce things. Same with most registrable IP. Like you're going to have to sue people to go after them if somebody rips you off. But enforcement's via contract, or this idea of breach of confidentiality, breach of confidence. Like I could share information with Kara, for instance, and even though we don't have an agreement, we all kind of understood it was secret. So you can actually sue on that. People can be proximate to companies. Like if you're a director of a company and you come into some secret information and then you kind of truck on your way afterwards and you use it for your own self-interest, yeah, you can cause issues there. Like it says at the end, this also works best when the data or the process is hard to reverse engineer. And that's just because like if the Word document with the ops plan slips out and anybody can take that and run with it, that's not really a good competitive or protective moat. So you need something that is a little bit more difficult to run away with. Okay. Next, reasonable measures checklist. We kind of talked about this a little bit, but you know, you can do some simple things. Like access control, not so much an issue if you're a tiny company. If there's like 3 people around the table, this isn't a big issue. But as you scale and there's more people coming into or able to access, I'm going to keep calling them state secrets. Does everybody need access? You know, think of it like you probably heard it in spy movies. There's a need to know basis for this information. If it is, great. If it's not, like you don't need to tell everybody in the company. NDA, people have probably heard about those. NDAs are good. Confidentiality obligations embedded in employment contracts, contractor agreements, just making people aware that you're working on secret stuff. A lot of the times when I talk about trade secret with clients, I'm like, yeah, there's contracts, but like, do you have a culture that respects confidentiality? Or like, if I go to the local watering hole on a Friday night, I'm going to find every one of your engineers talking about all the cool stuff you're working on. Like, again, people have to internalize and appreciate why this stuff is important and how if it leaked out to the world at large, it could be really detrimental to the entire company and them too. Marking and cleaning repositories of information, that's just keeping your data in good order. Like the stuff you have, we talked about it on the front end, the triaging exercise, being aware of what you have, trying to maintain good data hygiene. It's very useful. It's useful for IP strategies. It's incredibly useful for things like due diligence for investors or getting acquired. Vendor partner flowdowns just really refers to you're probably going to enter into contracts at some point with people who want to pay you money or you want to collaborate with them on building new technology. You have to be careful that now you're opening up this lockbox of secrets to them because they need to know some of that to help you out to collaborate with you or use your product or service. But it's now out in the wild. So are they under obligations? Like, are those contracts clear and they've got embedded little confidentiality or, woe is ye who take this information and use it in the public type language? I talked to the offboarding checklist is tied to a theme I talk about a lot too. And I kind of alluded to it with the culture point. It's the tie into HR. People are often your greatest strength and your greatest weakness. So when a person leaves a company, and if they've been there for a bit, there's a lot of stuff up here. Like we talk, you hear institutional knowledge capture, for instance. That's not just an HR issue. That could be an IP issue later on. If they were working on developing a new product or service and then they leave, and you need to make sure that the value of what they were building belongs to the company and they don't walk out the front door with it. Maintain a simple secrets registry. You can give it whatever cool name you want. Like I've heard people use all kinds of like weird names, like it came from a Jason Bourne movie or something like that. I wouldn't recommend that. I feel like the more you make it seem super, super secret, the more it's just like a honeypot for people looking. So maybe take it with a grain of salt. Give it a boring name or something like that. Like, last month's accounting files. Okay, AI and IP. Obviously, I'm sure almost every person on this call is either using AI, building AI, like incorporating AI in some measure into their company, et cetera. So, a few points on that. Like a lot of the conversations I find I'm having around this stuff is just dealing with, the training side and output. So right now, we don't really have a specific law dealing with AI copyright. Like there's consultations ongoing. People will know that we have a minister responsible for AI, Evan Solomon, who's trying to build out a larger AI strategy. A lot of those conversations, I will say, seem to be focused more on the privacy security aspects of AI than like IP ownership questions of this. I was just talking with a founder at lunch about this. I think a lot of where this is at right now is, I'm kind of jumping points, but it's that last point where I talk about human originality. So if I had a continuum, something that's entirely developed by human beings, probably capable of let's say a copyright registration. Something that's entirely generated by AI, probably not. You're not going to get that. Something that's X percentage human, Y percentage AI, maybe. Just depends. It's getting sorted out in patent and trademark offices, or here in Canada, the Canadian Intellectual Property Office. We don't know is the true answer right now. There's consultations ongoing. It's just one of those things to be aware of. If nothing else, document to the best you can, appreciating that AI is a black box in many ways. Document to the best you can what and where, what did the AI do? When was it injected in the process? What was its output, et cetera? We talk about keeping again, this is kind of the same point. Keep the data set provenance and logs associated. Where was the AI being used? What did it generate, et cetera. When you're doing your contracting associated with this, be clear on, say, the representations you're making about that AI, or, just almost like the guarantees. I mean, one simple thing that I'm seeing crop up a lot, and even just like baseline terms and conditions of use, is, look, you, dear user, are still a human and have to exercise critical thinking. So notwithstanding our product is going to give you the best soil analysis in all the land, you have to make the choice of what to do with your field. And if it leads to good things, great. If it leads to bad things, it's not necessarily our fault associated with it. So there's a important dynamic as part of it. Where a lot of the rubber hits the road are questions of ownership of outputs. And I think this is just because on the customer side of the equation, customers who are sitting on treasure troves of proprietary walled garden data know they have a gold mine of data and know you want it. I have a client who operates in the medical technology space. They provide software for different hospital networks in the United States. Those hospital networks absolutely know the value of that data that's being shipped out, from patient interactions, surgical records, et cetera. And setting aside, health information, privacy related compliance and all that concerns, they know this is a gold mine of data. They're not just handing it over to the vendors and saying, sure, like, exploit our data and we'll see where that goes. Like, we won't ask for any concessions on pricing or ownership or anything like that. But there's value in that. So the takeaway here is this is still an evolving point, but keep tabs on, if you are using AI to generate output, where is that occurring? How's the AI being used? What are those outputs, et cetera. And then I already kind of alluded to this. Look, there's the big angle of this, though this is not strictly on IP matters. I'd be remiss if I didn't talk a little bit about the privacy side of it, because this is driving a lot of the conversations around AI, generative AI. All I'll say here is the Office of the Privacy Commissioner of Canada has these general AI privacy principles focused on things like transparency and consent and safeguards. And a lot of it are the same principles that apply generally to privacy laws at a federal level. But I think that's worth keeping an eye on what those principles are. They're not law, just be very clear. It's not like you have to do them. But I will tell you, I see many customers, that's my second point there, that treat them as a bit of a checkbox when they're procuring AI solutions from vendors. So just be aware of those. I'm not going to walk through all of them because we'd spend a lot of time on that. But again, it's the Office of the Privacy Commissioner of Canada. They have these general AI principles. Okay, something a little more specific. So assignments, waivers, call that contracts more generally. So in this case, like, what do you need in writing? I mean, look, in a perfect world, you're going to have pretty much anybody who's ever touched the idea, the prototype, the creation, the invention, whatever you need to, the code, to sign something. Like, they have to sign something. And it's amazing how over the years this happened. This can cause problems. I had a $20 million financing almost go sideways a couple of years ago because when the company redid the website, they didn't get proper copyright assignments, moral waivers, that's the second point, from the person who built out the website. That almost screwed up the deal. And thank God that one of the co-founders, who was his buddy who worked at some, creative digital marketing company that did the website, we were able to get it. But if that person was no longer available, or they saw it as an opportunity to hold my client over a barrel, that wouldn't have been good. So try to get it real time. Like, when people are joining the team, like even simple things. I mean, people forget about this from the perspective of, oh, but I had unpaid volunteers working for me. I had some students. I built it at a hackathon. Still counts. Got to get something. Time and place, though. Back to my point, like, there's something for every season. In the beginning innings, to avoid scaring the hell out of people, maybe you don't need the 15-page assignment. Maybe you just need a one-pager on that. So you don't need to over-engineer this stuff. There's a point in there about moral rights. Just a quick one on that one. This may have been covered in other presentations. Moral rights are more focused on, like the name implies, it's the medium and the context in which a protected idea is used. So, I developed some type of specific holster and casing, but I don't like guns, so I really don't want it used in like for weaponry purposes, or maybe I have issues with something being used for drug manufacturing or something like that. I don't like the way that it's situated in that. You can't assign them, but you can waive them. So the inventor has a right to say, I didn't intend for my creation to be used over there in that context for that purpose. Again, it's easy enough to get, it's just a waiver. It's nothing crazy. And then a point at the bottom. Look, a lot of people assume if somebody's working for you, well, doesn't that mean I get it? Like I paid for it. They work for me. Maybe they're an employee, T4able, or they're a contractor. Again, that default might apply. Better to not find that out though. Just get a contract with them sorted out. Like a lot of this stuff, a lot of these issues are easily fixed by having templates for the different people on the journey. You know, I've got templates for contractors, employees, volunteers, like hackathon participants, people who are building startups as part of an entrepreneur class at a university, assignments that require specific nuance because one person on the team is a professor at the University of X or a postdoctoral fellow or a grad student. On that point, be especially careful of whether people have side gigs and are involved with other organizations. Assume if they're working for a large monolithic entity, a university, giant national company, there might be some policy there in terms of their day job trying to capture some of the IP that they're developing while in your service building a startup. This is why universities have things like tech transfer offices. This is why very large corporations have adjuncts of their HR offices where you can get waivers and exceptions so that when you leave, I don't know, Wells Fargo, they're not like, actually the FinTech app belongs to us. We're going to take that from you now. Have a nice life. You do not want that. On to the next point. So practical chain of title, we kind of covered this already. Anybody who's contributed signs something, including retro assignments for pre-incorporation work. And again, that's why I sort of walk through these examples that talk about ideation stage conversations. I've had lots of clients who were born out of hackathons and people leave the band along the way. You still need something from those people on the way out. So do that. Again, continuing theme, document, 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 a chain of title, chain of custody for people who like crime dramas. There's a good metaphor. A binder. Where did it start? Who came up with it? Did we sign something? Who contributed to it? Like all of this stuff should be documented somewhere so that if you're called upon, maybe that's because you're going to pursue some type of registrable IP. Maybe it's because of due diligence associated with some event. Could be fundraising, could be a sale, could be getting a government grant, frankly. That's important. Documentation, very, very important, eminently within your control as well. Okay. Deal terms. So I think at some point, everybody on this call, like assume if they're building a company would like to make some money. So you will have to deal with things like, well, how does that work in terms of the deals that I made, the customers that I signed, the collaborations that I signed off? How is this going to impact potentially selling the company? And so there's this idea here. I won't take credit for it. I can't exactly remember. It came from the 5 lever scan, which are just, if you look through something like a license agreement or anything dealing with IP, you're going to see these headings on there, like scope, field, territory, and users. So like, what field is this in? Meaning, is it the agriculture sector? Is it manufacturing? Is it aerospace? Territory. Is it Manitoba? Is it Saskatchewan? Canada? The Earth itself? I think I saw one years ago that was almost laughable. It was trying to cover like the solar system or something. I guess they're trying to get ahead of like Mars IP or something. Our users, is this only for a big one that actually comes up a lot? I'll focus on this one is, are you licensing your IP to people for internal consumption or external consumption? Like, are they going to take what you're building and then go out to market and be like, look at this amazing thing that we've like pulled together, like value-added reselling? Or is it just, it actually helps our employees track their time better or their shifts or something like that? So that can be a big difference because once they're out in the world with it, like the more people out in the public eye that see it, more opportunities, potentially more money, more risk associated with it. So scope matters. Exclusivity can matter. Did you say that this was the only person in Manitoba, or again, a larger thing like Canada that can make use of your technology? Or was it more geographically limited? Was it fenced in for a particular period of time, like you get exclusivity for a year or 6 months, or it's exclusivity tied to like volume of this? Like, I'll give you exclusivity to sell my IoT sensors for tractors, but you have to sell at least $1 million worth of product each year or else you lose it. Okay, that's something as well. Improvements, again, if your customer actually comes up with a cool idea and builds something out of it, who owns that? I was talking about this earlier with the healthcare networks. More sophisticated customers are not ignorant to the fact that, hey, there's some value here beyond just me giving it to you, dear startup vendor. We're going to have a conversation about that. Maybe we want to develop stuff. This is also a good one to watch for if you're chatting with counterparties. Like, this can often betray whether or not they're going to Trojan horse you in terms of taking what they've learned about your company and then building a competing product. I just went through that this morning with a reseller agreement where like we got a lot of resistance about like reverse engineering language. And I was talking to my clients saying like, are these guys going to rip you off? Because it really seems like they're going to do that. So anyways, so we're having that conversation. Feedback, same thing. If you're fascinated with your customers, and I'd suggest you should be, they're going to give you feedback. Some of that feedback might actually find its way into a product roadmap, could find its way into an IP registration. Very important. And then this last point is more like stuff coming into the relationship, stuff created out of the relationship. We talk about this a lot in things like, I kind of, largely call them collaboration agreements. You might think of them if you heard partnership agreements or joint venture agreements. People will come into that relationship with some of their own IP, background IP, but they'll create new stuff. So again, if me and, again, picking people's names off of this, me and Curtis collaborate on something, who owns the things we create? Who owns the outputs at the end of the day? Are they more valuable to his business or my business? Could he get by with a license over those outputs? Or does he need to have full ownership? All these things are not only important just from a negotiation perspective, as you're probably thinking about that, but they really impact upon when you're trying to sell the company. Because if you've established really narrow, difficult to get out of relationships, that may not be a good look for the buyer. The buyer might have wanted more agency when they bought your company, more flexibility. So they're going to want to understand what constraints you've built in. How far have you taken this IP that they're buying at the core, because you're an innovation-focused company, and how far have you sliced and diced it all over the world to all kinds of different people? Maybe that's okay if you're getting a lot of money for it, but you have to think about, are you making it too difficult if you, for example, had to unwind some of these things? So again, you can watch for things like irrevocable, perpetual, like all of that type of stuff. Okay. I talked a little bit about some of these earlier, but just some landmines I typically see related to IP when we get into sales situations. By the way, these are equally applicable too. I know a lot of people aren't necessarily on the journey about as far as like, I'm going to sell the company, but I know a lot of people are at least talking to investors. And so the same stuff's going to come up in investor due diligence. So take it closer to home on that. I could probably say M&A or raising, money landmines. Okay, ownership, we were talking about it earlier, like ensure clear title and ownership to crown jewel assets. Some licensing is fine. You hear the old saying, do I build, do I buy it type of thing. Consider though that in my experience, most sophisticated investors, collaborators, buyers, if you are at your core fundamentally a business that, optimizes roadway construction, and your AI that scans the roadways is actually a license and is not owned by you, versus say like, geolocation of, machinery outside that's doing this. If everybody's wondering, it's because I'm looking out of my office window and seeing people do construction. So this is literally how I come up with ideas, just things that you see. But like, you have to own that. That's like the core of your business. You could license other stuff. That's fine. ensure you have clear ownership of your crown jewel assets. That goes back to documentation. I won't repeat the stuff we talked about on the trade secret slide. Open source software, this is just the part on the, for the software heavy companies, you're probably using some measure of open source software. That's fine. This is not like open source software is bad. If you're doing it, make sure you're documenting it. Make sure you also appreciate that there are so-called good licenses for this and bad ones, often called copyleft ones. Again, this is not an open source software presentation, but it's tied to the concept of ownership, because some actually, despite saying that it's open source, are not actually that open, and you don't really acquire any ownership in anything. So understand that. Disputes and challenges. So this one, I think most people get this intuitively. Obviously, if you've had former employee, former co-founder, former business partner claiming legal disputes over things they owned. I used this at lunch. It's, I think, everybody's favorite example, thanks to the Social Network movie from many years ago. The Winklevoss twins claiming that Mark Zuckerberg ripped off Facebook at his time at Harvard. Disputes are not always just legal disputes. Anybody who claims infringement, justifiable or not, or claims that that was their thing, that needs to be reviewed, and you need to have a plan for that. Like, even bullshit claims can derail an acquisition, because often when you get into due diligence, the question is holistic. It's not, are you being sued? Like, if I truck off to the courthouse in Winnipeg or in Saskatoon or whatever, do I see a lawsuit? No. This is like, was there an email that was sent to you saying that you guys ripped them off? It might be entirely fabricated, but you still need to consider it. Most lawsuits begin, they kind of like germinate up from being these initial, like, fairly illusory complaints to larger things. So be aware of that. Complex organizational structures, probably not an issue for people on this call, but as you can expect, as people grow and scale internationally, their corporate structuring gets more exotic. I have a Canadian parent and it has subsidiaries in the US, the UK, South Africa, China, etc. Maybe I have a IP holding company located in a low tax jurisdiction like Ireland, and it enters into licensing agreements all over the world. That's what Apple does, interestingly enough, or so I'm told. I don't do their work, but I read it somewhere. In that case, if somebody's buying you or putting money into you or just collaborating with you, who's got ownership? Like, in that case, does it feel like a big shell game, like at the fair, where you're like, well, it was here, but it's over here? We need to know where ownership lies. And then also the extra levels of complexity of operating in different jurisdictions with different IP laws as you scale. Unfortunately, folks, as you scale and get into other jurisdictions, you will need to pay for experts in those areas. I don't do law in Costa Rica. I would love to. I hear it's a great place, particularly when it's -40 outside, but I don't do that. I use that example because one of my very first international foray things was back when I think I was a lawyer for 1 year, and I was doing work for a website developer, and they started getting random inquiries from people in Costa Rica to do their website. The founder had no idea. I was like, are you advertising there? She's like, I don't know. I haven't even been there. So there's laws in different countries, and that can nuance some of the ownership associated with your intellectual property. And then I kind of alluded to this earlier too. If you enter into, and a lot of companies do, these can be very useful, collaborations with other companies, partnerships, joint ventures. Again, who owns this stuff? There's going to typically be some agreement that fleshes all of that out. Like, you need to have those conversations on the front end with your potential business partner about creation, ownership, use, licensing of intellectual property. And then that needs to be well documented. So if somebody does want to buy you, they understand that they're buying you, but they're also getting into business with me because I was collaborating with you. And what does that mean to work with me? So keep in mind all of that. Keep in mind those points as well. Ownership models you can use. This is more getting at the collaboration stuff. So there's like the contractor owns it model. That's very useful if you're the contractor, and like it's very friendly for startups or whatnot. Like, we own everything, and then like customer, you might get a license back associated with it. There's the flip side of that, which I think is very difficult to square the circle on for companies where the customer owns everything. Again, wouldn't necessarily say that's the best approach either. You're probably seeing a little theme here, which is like the Goldilocks, not too hot, not too cold, somewhere in the middle. There's the reason I actually use this, that last slide probably seems funny to a couple of people. Again, that's only in there because, as it turns out, if you Google contractor ownership model elections Canada, and like I said, there'll be slides and I'll provide the hyperlink. There's actually some sample language that Elections Canada, of all places, uses for whether the Crown, the customer, owns the outputs of a vendor relationship or whether it's the contractor that owns it. And it's actually not bad. Again, I'm not saying, like I said on the front end of this presentation, everything, context matters. But just to give you an idea, when we talk about, well, what does this mean from like a legal language perspective? There's some interesting definitions in there back to that background IP, foreground IP definition. Again, I just wanted to provide it because if I made the whole presentation where I showed you clauses in a contract, everyone would go to sleep. But I know at some point people are sort of like, well, what does this actually manifest as? So as it turns out, Elections Canada actually has some like decent verbiage to look from on that side of it. So that's that. Okay, your call to action on this. So surprise, surprise, it is an ElevateIP presentation afterwards. Turn it into a work plan. I mean, it says ElevateIP, but take this into some type of work plan. Scan your assets, pick some default postures, meaning like, are you going to go down and pursue a trademark? Or are you going to keep it super secret, trade secret policy or whatnot? Are you going to conduct a wide swath of searches first to understand the state of play? Or are you like, I absolutely know what pond I'm fishing in. This is now a question of just taking full advantage of registering, acquiring, identifying everything in that pond. Chain of title, tighten deal terms up. A lot of that is just contract and process hygiene. Like we talked about it again and again and again, like just have good documentation practices. It's amazing how that helps for any number of things, like IP for sure, but more critically beyond that for like mergers and acquisitions, diligence, capital raising, all of this other stuff. And apply to Elevate. I know you're all in ElevateIP, but you know, talk with experts, talk with other individuals, take advantage of these webinars like you're doing here. You'll learn some stuff you can incorporate into your strategy. That becomes really important. And, you know, I'd be remiss if I didn't give a plug for us. For the North Forge founders, we do have a Notion page that has been developed. It has some legal resource library stuff, which is, again, some quick hitter summaries of some issues, some IP, some beyond that, some legal tips, some sample contracts as part of it. I actually think I was alluding to it earlier, like template contracts for volunteers, contractors, employees that include IP language. I actually think that's in there. It's free, even better. So you can access some of that information along the way. And, you know, of course, have to include a presentation with a nice picture of me. It's funny, I didn't take that long ago, but I like my beard and my hair are significantly grayer than that. I've also grown out my hair because, as my wife says, I'm accelerating my midlife crisis. So it's not complete until I buy a 1960s muscle car. That's when I've truly descended into madness. And that takes us to the top of the hour. And I wanted to make sure we had time for Q&A. I say this, I also include that picture in jest. I talked about it earlier. IP is important, but it also matters everything else in your business along the way, like whether people are actually paying for that product. So I hope this was helpful. I hope this was tactical. I'll reiterate again that we are going to be sending and kind of aggregating all of these points in a checklist that we can provide to everybody in the aftermath. Hopefully that gives you some food for thought. And again, some tactical takeaways you can use. So you either own it or you're going to lose it. So thank you for the time. Happy to answer any questions.
Hello. Thank you so much, Joe. That was fantastic. You're a fantastic speaker. We have a few questions for you, and I'll just read them out and let you answer them. So sure. The first one is from Perry. He's asking, can you explain the importance of patents and patent searches?
Yeah, absolutely. So I kind of touched on this earlier. I'll start with the back half of that question on the searches. Like, I really think searches in the patent terminology, landscape searches are really important. We see them a lot as part of ElevateIP engagements. And I think that just underscores the importance of understanding the field of play. Like, even though you may come to the program and you say, I have this amazing product, you know, we've been working on it for years, we've prototyped it, that may be the perfect thing to proceed to a patent registration. But do you truly know what's out there in the world? Do you truly understand the state of innovation? Maybe you do, but I tend to think that the searches are very good precursors to help you nuance your strategy as part of that. As for patents, obviously, if you have some innovative, piece of technology, hardware, etc., this becomes really important. It's more, I guess the issue is it depends on the nature of what you're building. Like certain things are just better candidates for pursuing patentability than other businesses that might have more of a trade secret or a trademark. Like there are lots of good companies out there that they're not really I find this a lot more in consumer facing companies. It's not that they have some type of deep technology item that they could pursue a patent on, but they're really just protecting their naming and their branding associated with it. Maybe they have a network that's really important. So the brand and everything associated with that is really much more important, because behind the scenes, it's actually not that innovative. It's just a network for people to collaborate for, I don't know, like pet food supply or something like that. So hope that kind of hits on there. I could see some of these too, Kara, I guess Justin's. Does it just go top to?
Yeah, there is one that we got in the chat that I'll read just before
Oh,
those.
sure.
It's
Yeah,
from Sophia. She says, for AI SaaS startups, software patents are often difficult. What forms of IP protection are realistically effective in this case?
Yeah, it's. I mean, we talked about this. We talked about this earlier in the presentation, Sophia. Like it's a really evolving area generally in terms of patentability on things that are created heavily with AI. SaaS related companies and software patents generally have always been somewhat difficult, but I think this is where the documentation point really comes in, like understanding at a deep and granular level how you're using AI as part of building out your software, how it builds into the user experience, what outputs are coming out of that, and just having that ready. And in many cases, for the time being, kind of falling back on that trade secret point until there's more nuance around this. Because again, I am confident we're going to have more consultations at a federal level, might even see legislative changes to things like the Copyright Act, the Patent Act, et cetera. But we're not there yet. But I know once we get there, if you've been diligent about documenting the creation, use, et cetera, of AI, it's going to serve you that much better when you get there.
Perfect. Thank you. Justin says, can we list multiple processes and UI designs in one patent? How vague can a patent be and still be secure? For example, a detailed process of how the system works, but leaving out the multiple ways. I think the end is cut off, but you get what I'm asking.
Yeah. I mean, this is like, one way to answer this is kind of back to my Goldilocks metaphor of like not too hot, not too cold. Like if you make something too vague and too broad, you will probably not get approval for that at the patent office. The other flip side is if you make something so granular and so narrow, you may not actually get the protective moats you need to avoid competitors coming into the space associated with that. So it's so heavily context driven. Like I was about to say it depends, but everybody hates when lawyers say it depends. But that one, again, the framing around how narrow, how broad, how nuanced, what industries, what functionality, et cetera, that goes into something like a patent application or an industrial design application. Like that's an art in many ways. Like there's not a one size fits all answer with that. All I could say is if you try to jam in a whole bunch of stuff, I can guarantee you're going to run into problems. It may not be an outright rejection, but you may get it back from the patent office and they may say, look, like go back to the drawing board and nuance that a bit more.
That's perfect. Thank you. We also have from Sophia, what is the best way to manage open source usage so that it does not become a landmine during M&A or future investment?
Yeah, I mean, again, same thing I've talked about multiple times here. Document usage, like understand where open source is being used in the development of your product or in your software, basically. Again, it's not bad to have open source software, but make sure you have documented instances of where it is used and make sure you know exactly or have a link to the particular terms of use of that open source software. So I referred to this earlier. There's so-called copyleft licenses, which are not generally great to use as far as open source is concerned, because They require a lot more than just attribution, like naming that this came from somewhere else. Some of them do really extend into ownership, and those will cause red flags. Like I know, for example, sophisticated buyers in the tech space, they will run full scans on your entire tech stack, and they will be able to identify where open source software is being used and flag immediately, okay, like this is good, this is good, this is good, this is good. Nope, this is a problem. Like explain to me why we're using this. Explain to me how you're complying with the particular license associated with that. So again, it comes back to inventory.
Thank you. And we have time for one more. The question is it appropriate and can one protect as IP something used in the basketball industry and reimagine it to apply to the same industry to work and apply in a new way?
Yeah, I mean, I'll punt on the basketball industry, but I'll answer it this way in that, look, in many ways, IP protection is about the creative transfiguration of basic things. And I've explained it over the years as this. One of my guilty pleasure shows every now and again is to watch like the Food Network when they do like those cook a whole bunch of stuff. There was a show at one time, I think it was called the Mystery Box Challenge. So they put 3 chefs up there and they have these boxes. And in each box is a whole bunch of ingredients. And it's usually weird stuff, like gross things in there that you wouldn't want to cook with. But there's a bunch of regular things on top of it. The ingredients in the box are your basic inputs of things. You can't get protection on those. No one can own a banana, right? But when you take the time and apply human insights, human creativity, your own thoughts, your own experience, and you build that amazing, I don't know, dessert at the end of the day or main course, that's probably protectable under some head afterwards. So you can take things that are known, generic in an industry and reimagine them in a way that people didn't think about. And you probably can get protection for that. It's like where we get into terms under patentability about, was it obvious to everybody else? Like, if you pull, take your basketball example. I pull 10 basketball players. Would they have ever thought that you could use the netting for this purpose over here? And if most of them go, I would have never thought about that. That might actually be a good candidate. If 10 out of 10 surveyed say, absolutely, anybody with half a brain would know you can use it for that purpose. Probably not as much.
I love that. Thank you, Jill. That's perfect. So this concludes the formal aspect of our webinar today. We're all going to go back into the networking space, and there's about 3 minutes left in the event just for some final discussions. Thank you so much to everyone for joining. Thank you so much, Joe, for your keynote presentation today. And like Joe mentioned, I'll be following up most likely by the end of the week, early next week, with some tidbits from Joe and a survey for everyone to fill out. So thank you very much and have a good rest of your day.
Thanks, everyone.